Hello, good morning. On behalf of Young ICSID, I would like to welcome you to today's program, the launch of this new book entitled Public Purpose in International Law, Rethinking Regulatory Sovereignty in the Global Era. We're delighted to have here with us today the co-authors of the book, Mr. Pedro J. Martinez-Fraga and Mr. C.Ryan Reetz. First to start, now let me introduce you the co-authors. Mr. Martinez-Fraga is a partner in Bryan Cave LLP, International Arbitration and Litigation Practice Group. He is the firm's co-leader of the Arbitration and Litigation Practice Group globally. Mr. Martinez-Fraga is also the co-founder of the Miami office. On December 16, 2015, Mr. Martinez-Fraga was appointed to the ICSID panel of conciliators by the United States of America. He has represented 7 countries as lead counsel and served as an arbitrator in ICC and ICSID proceedings. He has written numerous articles in different languages and published 5 books on public and private international law. He is currently an adjunct professor at the New York University School of Law. He also serves as a full-time visiting professor at the University of Navarra School of Law in Pamplona, Spain. Mr. Martinez-Fraga is a graduate of St. John's College of the Columbia University School of Law. He also holds a licenciatura, magister, and PhD cum laude from the Universidad Complutense de Madrid. Now, let me introduce you his co-author, Mr. Ryan C. Reetz. Mr. Reetz is a partner in Bryan Cave's LLP International Arbitration and Litigation Practice Group. He's also a co-founder and co-managing partner in the Miami office. He represents clients in international and domestic commercial and regulatory disputes and has served as an arbitrator in international commercial disputes. Mr. Reetz has written numerous articles and lectures on arbitration and litigation topics. He teaches transnational civil litigation and arbitration as an adjunct professor at Emory School of Law and taught the same subject before at the University of Miami School of Law. He also serves as a visiting professor at the University of Navarra in Pamplona, Spain, and is the 2015 Scholar in Residence of the New York University School of Law. Mr. Reetz is a graduate of Harvard College with a degree of magna cum laude and a Boston University School of Law with a JD of summa cum laude. With this, I open the floor to Mr. Pedro Martinez-Fraga and Mr. Ryan Reetz.
Well, thank you very much for the kind introduction and the warm welcome. It's really a pleasure to be invited here to come talk to you and plug our book. I wanted to start by the way, I'm Ryan, he's Pedro. I wanted to start by talking about someone that we left out of the book, a great American baseball figure who passed away last year, Yogi Berra. And at least those of you who are familiar with U.S. culture know that he had an elegant way of inelegantly stating certain truths. For example, probably his second most famous yogism or yogi statement was, "It's déjà vu all over again." And perhaps more relevant to what we wanted to talk about today was his saying that when you come to a fork in the road, take it. And that, in a nutshell, that's really how we came to look into the subject of public purpose in international law. What do we mean by public purpose, and where do we encounter public purpose in international law? Well, the second is kind of a silly question to ask here at ICSID, I guess, because in our practice, we see public purpose in the context of investor-state arbitration, and particularly in the context of international law concerning the expropriation of property by aliens. And it's mentioned, the public purpose idea is actually mentioned in the general rule on expropriation, where it's stated in various treaties and in customary international law that states cannot take the property of non-nationals except for a public purpose in a non-discriminatory manner pursuant to due process of law and upon payment of just or prompt, adequate, and effective compensation. So we see public purpose right in that expropriation standard. And we see it, as I said, in BITs, we see it in multilateral treaties, we see it in investment protection agreements, and various other contexts. Where else do we see public purpose? We also see it discussed occasionally in the context of indirect expropriations. where a state doesn't actually directly take away the property of the foreign national, but rather regulates it or burdens it in such a way that it is effectively depriving the foreign national of the value of ownership. And in that context, we see public purpose used as a concept or an idea to mediate the tension between the state's obligation and duty to regulate and the state's equal obligation and duty to protect foreign investments. And we'll talk a little bit about how that concept is used to mediate that tension. What does public purpose mean? Well, we see that it's not defined anywhere in the treaties or other sources. And there's really not much detailed discussion of its meaning, really not that much even of its application in the indirect expropriation context. And so that raises a couple of interesting questions. If it's not defined anywhere, what does public purpose mean exactly? And what are the consequences of whether a taking, an expropriation, is done for a public purpose? As to the term's meaning, there is a historical view, which I think Pedro is going to talk about in more detail. And the historical view says that whatever public purpose is whatever the state deems to be in furtherance of its own ends. In other words, if the state says, this is good for me, then it's a public purpose. And that's really, we think, the historical view of the concept. As for its consequences, there seem to be two main consequences in the field of investor-state disputes. The first consequence is the distinction between legal and illegal expropriations. If an expropriation is not for a public purpose, then that would be one factor that in and of itself would make the taking illegal. There could be other reasons why an expropriation could be illegal, but taking not for a public purpose makes it illegal. And a number of authorities, beginning as far back as the 1928 case in the ICJ, the Trozo factory case, suggest that if a taking is illegal, then a different standard of compensation may apply, a more favorable standard for the claimant. Full compensation rather perhaps than prompt, adequate, and effective compensation. The second potential consequence of a taking not being for public purpose, or rather a second potential consequence of the meaning of public purpose, is the authorities that suggest that whether a state's regulatory activity, regulation by the state, is for a public purpose, affects whether that regulatory activity is an indirect expropriation. If the state is acting for a public purpose, then it is harder to call the state's regulatory activity an indirect expropriation, at least according to some of the authorities that we've seen. But given this very broad historical definition of public purpose, whatever the state deems to be in its own interest, and that could apply to almost any state action, because what state's going to say, I did this, but it's not really for a public purpose, the consequences of something not being for a public purpose would never seem to come into play. If the state can tell you my action is for a public purpose, then it's sort of self-proving, and we're never going to see anything that's not for a public purpose. And that is actually recognized in the U.S. Restatement Third of Foreign Relations Law in one of the comments. And that's another topic that I believe Pedro is going to address in more detail. But it's recognized that we don't see a lot of this because of the historical view of the meaning of public purpose. And that's really what led us to the proverbial fork in the road, a fork that we took. We had to either accept that public purpose is essentially meaningless language in the context of the international instruments, for example, the bilateral investment treaties. It's a test which has no consequence because it's always met. That's one option. The second option is to try to arrive at a deeper understanding of the doctrine, to see whether there is a way to give it some content, and to see whether the doctrine in its current form adequately addresses the needs of the international system. In other words, although the doctrine is historically viewed as very broad and self-judging, is that appropriate in a world that has become highly interdependent? Going back to our, by now, good old friend Yogi Berra, he also said, you've got to be very careful if you don't know where you're going, because you might not get there. And we decided to try to know where we were going. We decided to look at the public purpose doctrine from three perspectives: a historical perspective, a descriptive perspective, and a prescriptive perspective. And in the context of our looking at the doctrine, we found it's not an isolated concept in investment law where we practice. It's found, as we would submit, a single concept across a broad range of international legal fields, not just in the investment treaties and customary international law, but in international human rights law. It's even reflected, we contend, in national legislation. And we've identified a number of concerns with the doctrine in its current formulation and a number of suggestions as to how to improve treatment of it. But it really began with the history of the doctrine, how this all came into being. And for that, I'd like to turn the microphone over to Pedro.
Thank you. I'll relieve you. I'm not going to talk about Yogi Berra. But imagine this. We're talking about a doctrine that is ubiquitous in public international law. It finds itself in over 3,000 bilateral investment treaties. Certainly it finds itself in the NAFTA and in the DR-CAFTA. Those who say that the concept is absolutely of no weight because it is self-judging, it is subjective, it leads to all or nothing results pursuant to which proportionality is completely excluded and read out of the concept, and that therefore it has no relevance, I assure you that it has tremendous relevance. And the relevance that it has is fundamentally holding back crucial aspects of the development of public international law and leading to inconsistencies that are pragmatic, not just of a theoretical nature. Now, Ryan mentioned that our approach is historical, our approach is descriptive, and then prescriptive. That's just a pompous way of saying that we looked at what was going on before, what's going on now, and what we think it should be. And in terms of what we think it should be, Ryan will talk about that. We have a non-exhaustive list of how we think this can improve. The question becomes this: is there a hierarchy of public purpose? Does public purpose help or hinder the regulatory activity of the state by carving out a reservation of the state's exercise of its sovereignty in imperatives where private individuals have no say? Does public purpose, should it affect compensation or liability in public international law disputes? Does public purpose, should it be treated differently if it is codified in a criminal statute? These are issues that are fundamental. Now, because I don't really believe in the methodology we selected, if our premises are correct, the methodology doesn't really matter. In other words, the historical, descriptive, and prescriptive approach is only an organizing feature if its actual elements are correct. For that reason, and I'll assume that the actual premises are correct, as mere premises, I'm going to start a little bit, before I get into the historical with you, I'm going to start with the descriptive, where we are, and what is the nature of this problem. The question that I want you to keep in mind as we get into the historical aspect, and I share with you that the historical foundations of public purpose, and therefore the problem that we have with public purpose, namely that it is an intuitive concept, self-judging, leading to all or nothing results, excluding proportionality, that problem, the intuitive aspect of public purpose, is rooted in its history, in two aspects of its history: territoriality of ancient Greece and the language of ancient Greece. But first, what is the problem? What is the world we live in with respect to public purpose? Don't take it from me. Let's hear the restatements on foreign relations. I want to first show you, this will be historical. This is the restatement 712 of the Foreign Relations Law of the United States, second. This goes, 185, I apologize. The comment to 185, this goes back to 1965. 1965, this is the Foreign Relation Restatement. This is what it says on public purpose. Quote, "There appears to be few, if any, cases in which a taking has been unlawful under international law on the sole and specific ground that it was not for a public purpose. There is little authority in international law establishing any useful criteria by which a state's own determination of public purpose can be questioned." That's over 20 years ago. That's 1965. This is the restatement third. Now, one of the things we look for, as you know, from being practitioners, theoreticians, and people interested in this field is progress in the field. This is the restatement third, section 712, comment E, and I quote, "The requirement that a taking be for a public purpose is reiterated in more formulations of the rules of international law on expropriation of foreign property. That limitation, however, has not figured prominently in international claims practice, perhaps because the concept of public purpose is broad and not subject to effective re-examination by other states. Presumably, a seizure by a dictator or oligarchy for private use could be challenged under this rule." There's been absolutely no progress from one restatement to the next. Let me share with you Nico Shriver's analysis of public purpose arising from his book on permanent sovereignty over natural resources. And I quote, "In most relevant arbitral tribunals, the view has been taken that a lawful nationalization or expropriation must serve a public purpose," citations omitted, "but sometimes with qualifications. For example, in the Liemco case, it was held, quote, within the quote, as to the contention that the said measures were politically motivated and not in pursuance of a legitimate public purpose, it is the general opinion in international theory that public utility is not a necessary requirement for the legality of a nationalization." That's the end of that citation. Nico Shriver goes on. "While many conclude that the demand of a, quote, public interest or, quote, public purpose should be maintained, there is recognition of the fact that ultimately it is the taking government which determines the public purpose or utility of a particular expropriation, and that in many cases it can be taken as impossible that an international court or organization can, from a reasonable judgment on the accuracy of a claim by a state, that an action served a public purpose. In summary, a state is not completely free to determine the justification and conditions for nationalization, but it is bound by certain international requirements. In practice, however, it has wide margins of discretion." Now, the other question that comes to mind immediately is, well, what about the jurisprudence? To use that word loosely, of course, the decisional law in public international law. I suggest to you that it is equally bankrupt. It is everywhere on this issue. And the best way to see this, I think, for present purposes, let me just share with you 3 statements that I suggest to you will be dramatically different. Now, 2 of these statements really should be closer. One comes from the famous metal-clad case, you will recall. The second one will come from Methanex. The third will come from the Santa Elena versus Costa Rica case. 3 classical cases that we all do homework with. Listen to this for a second. This is metal-clad. Quote, "Expropriation under NAFTA includes not only open, deliberate, and acknowledged takings of property, such as outright seizure or formal obligatory transfer of title in favor of the host state, but also covert or incidental inference with the use of property which has the effect of depriving the owner in whole or in significant part of the use of a reasonably to be expected economic benefit of property, even if not necessarily to the obvious benefit of the host state." Here, there's clearly language of an obvious benefit and of effects. Now, why is that? The reason we will learn, and you already know, I'll just reiterate it in the context of public purpose, is because the effects test is a test that, in effect, that has the consequence of depriving host states really from the exercise of a legitimate public purpose because it focuses fundamentally on the effects and not on the proportionality of the regulatory measure on the actual subject of that measure. I want to point out to you also that in this metal-clad language that I shared with you, public purpose is not referenced. What is actually referenced as being public purpose are the interests of the state. Now, listen to Methanex, okay? Another NAFTA case. As a matter of general international law, a non-discriminatory regulation for a public purpose, which is enacted in accordance with due process and which affects, inter alia, a foreign investor or investment, is not deemed expropriatory and compensable unless specific commitments had been given by the regulating government to the then putative foreign investor contemplating investment that the government should refrain from such regulation. In Methanex, public purpose is so enshrined that compensation is not even necessary. Compensation is only reserved under the Methanex analysis and weight of public purpose if, in effect, specific representations were violated in connection with the investment arising from the exercise of regulatory sovereignty. Finally, Santa Elena. So now we've seen two dramatically different situations. One where the effects test trumps public purpose, a second where the public purpose trumps the effect test. We've seen that the restatement has made absolutely no progress in the span of 20 years. We hear the scholars echoing what the cases are fundamentally saying, namely that we don't understand how we can deal with this concept, that we just ignore it. If we ignore it, we see what happens. We get the inconsistencies. Now, this is Santa Elena versus Costa Rica. You'll remember that this was not necessarily, in my opinion, a very strategic case in terms of the property at issue. We're not, unlike Metalclad and unlike Methanex, both of which dealt with, as you know, very serious environmental issues. You'll recall that Methanex had great promise. It was supposed to be the great case that brings together awareness of how environmental issues actually play out in the realm, in the space of public international law. You'll also recall that that was the first case where an NGO filed an amicus in these types of proceedings in a NAFTA case. So it was very, there was a great expectations. It ended up having so many reiterations, reincarnations. The Supreme Court of British Columbia ultimately even weighed in on it. But Santa Elena, you'll recall, deals with hospitality. Now listen to this, okay? This is at paragraph 71 from that award. It's a 2000 award, as you recall. It says, in approaching the, quote, in approaching the question of compensation for the Santa Elena property, the tribunal has borne in mind the following considerations. First, now this is the tribunal's exegesis of public international law. International law permits the government of Costa Rica to expropriate foreign-owned property within its territory for a public purpose and against the prompt payment of adequate and effective compensation. This is not in dispute between the parties. Parties stipulate. Then it goes on to say, while an expropriation or taking for environmental reasons may be classified as a taking for public purpose and thus may be legitimate, the fact that the property was taken for this reason does not affect either the nature of the measure of the compensation to be paid for the taking. That is, the purpose of protecting the environment for which the property was taken does not alter the legal character of the taking for which adequate compensation must be paid. The international sources of the obligation to protect the environment makes no difference. So we see that we have a doctrine that actually does a lot. It tells you two fundamental things just in the realm of expropriations. First of all, it's one of the four elements in expropriation, but then it shows us that those four elements that define expropriation in the application, in the conceptual application of an expropriation, do not define when a state may, for imperative reasons, exercise regulatory sovereignty such that payment of compensation in furtherance of that exercise of regulatory sovereignty would have the effect of being a fine on the state, where the state is being fined, asked to pay money, is being punished, in effect, by merely complying with its imperative, with its obligation. An obligation which, if taken to an extreme extent under certain circumstances, and I'm not necessarily referring to a necessity defense, would be treason if not undertaken. So you see, ladies and gentlemen, the tension that we have. Now the real question is, why? Why all this? And I told you that it has to do with language, and it has to do with the way public purpose developed, and here's why, and this is how. In Greece, when we look at public purpose, when we first encounter public purpose in the context of takings, it goes back to the Greece of Aristotle, of Plato, even before that, before the Greece of the elegant analytics of Euclid and of the great playwrights. The Greece of Homer. We see that in the city-states, in the writings, Homer talks very clearly about the taking of property being justified, foreign property being justified for the greater purpose of the city-state. And the takings of foreign property that Homer is referring to is the taking of slaves, the taking of non-Greeks, primarily Persians and Medes. And the word that Homer uses in the masculine is demos, in the feminine demus. And when you translate that word, not too loosely translated, it translates into plunder with feet. So you can take things that are foreign for the benefit of the state. You can justify it so long as it's for the benefit of the state. The same concept keeps developing, again, language and territory, the state and language. And we find in the later writings of the more classical post-Homeric Greece, the word andropadon. And in the andropadon, there it's even clear that what's being discussed is plunder with feet, the taking of foreign property, the taking of slaves, defined as non-Greeks who come into the national territory, is justified because it serves the public purpose of the state. The state has a need for them. It enriches the state, and this justifies the actual taking that otherwise would be illegal and would not find any formal foundation in the structure of the polis. Now, I want to share with you that this type of taking is so embedded in the inward-lookingness, in the territoriality, that it's also tied up to the way the Greeks use the word the Greeks used for foreigners, barbaros, an onomatopoetic word that fundamentally means all non-Greeks. The inwardness and the territoriality in the language, you see it better with the infinitival form of the word barbazane, which really means the speaking of gibberish, the way, or the speaking of broken Greek, the way the Greeks heard the foreigners speak, they thought it was bar. That was the thinking. And so it's this inward looking based on territoriality, founded on language. You see its place in the intercity state takings and relationships with something that is a principle that is the single exception to public purpose in ancient Greece. In ancient Greece, there was only one exception to public purpose, and that exception was a treaty-based exception that was supposed to be divine in nature. Let me explain. The word is spodon. Spodon is the word for Greek, for treaty, but it's also the word for libations not served to the gods. You see, at the end of I'm not saying that wine is an exception to public purpose, but pretty close. You see, at the end of the signing of a treaty, what the Greeks would do, they would pour libations before they actually started drinking the wine. So this means that the solitary exception for the application of the public purpose doctrine in ancient Greece is something that has to do with practically the divine, that which accords normative standing, to a treaty. The only exception, short of that, public purpose was intuitive, self-judging in nature. And that's what has brought us to the understanding of public purpose that we have here. Now, leaving ancient Greece, what is the public purpose that we find, and where do we actually find it? Well, one of the ways in which you can analyze and study public purpose, now understanding its intuitive and therefore deceptive and elusive nature and character, and therefore application, is in the NAFTA. If you're going to look for it anywhere, NAFTA is the place to look at it for a number of simple reasons. First, the NAFTA, with 7 annexes, 8 parts, and 22 chapters, and then a decisional law interpreting the NAFTA. The NAFTA is a petri dish of public international law. It has everything in it. Moreover, the NAFTA, in all of its chapters, except 2, of course, it's a what? It's a commercial international trade treaty. It's not an investment protection treaty alone. It has investment protection features to them, of course, Chapter 11. But let me just say this, by the very terms of the NAFTA, those investment protection features are subordinated to the overriding international trade law features. In Chapter 11, 1101.4, the NAFTA does something that is extremely extraordinary, and I think very, very successful in helping us understand public purpose. Some have said that the NAFTA there defines public purpose. We say that almost. What the NAFTA does is much more sage than trying to embark on the definition of something so elusive and something that has to be flexible and transformative with time, circumstance, and even technologies. What the NAFTA does is it develops a standard. And that standard, I think, is very helpful, and it's laudable, and it's what has guided public purpose to some extent and taken it to a place where we can now start to think about revisiting it and revising it. Here's what the NAFTA 1101.4 says. It says, nothing in this chapter shall be construed to prevent a party from providing a service or performing a function such as 1, law enforcement, 2, correctional services, 3, income security or insurance, 4, social security or insurance, 5, social welfare, 6, public education, then it goes on, public trading, health, and child care, in a manner that is not inconsistent with this chapter. Now look, notice that what the NAFTA does not do is define it really. It doesn't set the limits. It provides no exhaustive list. Plus, it doesn't really provide a list at all. It provides examples. Critical to that language are the words such as. That's extremely important. Now, there's the virtue, but there's also the sin is there as well. Because such as, and the examples that were provided to us, although they range from police force and state security to insurance and the financial sector, there's no conceptual rubric for defining what is public purpose. And in fact, that definition, which stands there by itself, doesn't find commonplace throughout the extensive text of the NAFTA. In fact, what the NAFTA then does in other parts of its text is it provides you with practically an exhaustive list of what it considers to be public purpose. It goes on. Chapter 11 identifies 15 public purpose categories: human life and health, animal life and health, plant life and health, living and non-living exhaustible resources, general environmental, modification to technology to meet health requirements, modification to meet safety requirements. And it goes on. It goes all the way to government grants generally. So it doesn't really help us in the quest for a test for public purpose. In fact, what it's actually doing is nurturing the thinking that all things public, all things that have a welfare piece to them, are enough to become a public purpose. Now, this is obviously, this creates great uncertainty, and what it actually leads to when applied literally are exactly the type of contradictory results that we see in Metalclad and that we see in Methanex. But what it also does is it doesn't allow us to understand how, for example, some of the public purposes that the Chapter 11 in the NAFTA identifies are not even public purposes that belong to the protection of foreign investment. They're the public purposes that pertain classically to international trade law. So now we find that the public purpose that attaches to a narrow field is substantially broadened, in large measure because it is thoughtlessly being imported wholesale from the majority policies of what is in effect a trade and commercial law rubric. So that the laudable aspect of the NAFTA in many ways turns on itself, even though in doing so it provides us with a rich petri dish for the development and observation that may lead to the formation and transformation of a new public purpose that will actually comport with economic globalization. And that's fundamentally the problem that we have with the legacy public purpose doctrine. It arises where the actual paradigm that is prevalent at the time is one of national independence instead of national interdependence, one of territoriality instead of a transnational law that by definition is not international. It's not the law of one nation and another nation, but transnational, no borders, like human rights law. And when we do see human rights law, there we see that public purpose helps us. States can intervene within their national territories and infringe some types of human rights if it serves a public purpose, like, for example, the human right to free assembly. But can a state really interfere and violate the human right to be free from torture, the human right to have a name, the human rights of children? Those human rights, the human rights of jus cogens, they don't have a public purpose component to them. They are beyond public purpose. They are jus cogens. They don't need public purpose. So here we see that public purpose actually helps us create a hierarchy in human rights, and therefore also a hierarchy of public purposes within the space of the protection of foreign investment. Do you want to talk about FIPS, or do you want me to do that?
Sure.
Okay.
You're on a roll.
It's time and a half from here forward. Let me tell you, these are the issues, but I think what's meaningful is for us to also focus on existing frameworks that allow for a solution. And I think that one way of doing this is to focus on what we have identified as FIPS, Foreign Investment Protection Statutes. Now, as you know, most states in the world of commerce have FIPS. But the way we've looked at, I can't tell you we've seen all the FIPS that are out there, but we've seen over 100 of them. And the United Nations recognizes, I think, 192 countries, excluding Kosovo, Vatican City, and Taiwan. We've seen them fall into three fundamental categories. You find foreign investment protection statutes that are geared towards creating guarantees for foreign investment. They will tell you fundamentally that that foreign investment is safe. Now, I will show you in a few seconds that that's absolutely categorically not true because of public purpose. The second type of FIPS that we find are the FIPS that offer economic incentives and are low on protections. And these abound, and these appeal to fundamental greed. The third universe of FIPS that we find are the FIPS that are neither incentive-rich nor offer any guarantees for foreign investment protection. China is the perfect example of this third type of FIPS. But when we look at the FIPS that are really interesting to us, those who try to actually create protections so as to attract foreign investment on that basis, we learn a lot. For example, we learn, first of all, that they are wide-ranging. On one extreme, you have the wonderful foreign investment protection statutes of countries like, for example, Egypt. The Egyptian Foreign Investment Protection Statute provides, on its face, absolute ironclad guarantee against expropriation, direct or indirect, creeping expropriation, or a fourth category, activity tantamount to an expropriation, which, by the way, a lot of us practitioners and people who like this kind of stuff confuse. We confuse conduct tantamount to an expropriation with a creeping expropriation or an indirect expropriation. They're different things. They may overlap in some instances, but they're different things. And because they're different things, they have different aspects of public purpose that attach. And the analytical framework for them is different, and compensation is different, and therefore liability is also different. So I share that with you. While you have Egypt providing for this absolute guarantee, you have countries like Vietnam, the Republic of Laos. These countries tell you that you have fundamentally safe foreign investment protection against everything except, of course, in cases of a public purpose. And here, again, we run into the problem that we've been wrestling with throughout. The actual FIPS, the actual language of the FIPS, and I'll spare you because this is, after all, a long weekend, and you deserve better than to be exposed to this type of thing. But I will tell you this. When you read it, you will immediately see the public purpose. Others define public purpose, and they will say if it's war, if it's national security, and they limit this type of public purpose. So, what am I saying with what the FIPS teach us? FIPS teach us a lot. If you have states that have enacted these legislations, how can they then shy away from the meaning accorded to these terms when they're litigating over a supposed breach of a treaty protection standard? Similarly, with respect to a claimant, the foreign investor. You, foreign investor, know what your country, or presumably, or you should know, what your country enacted, how your country treats these subjects in terms of nationalization, direct, indirect, creeping, and tantamount. You've defined it. And you know how the host state has legislated on this issue. I submit to you, should this not go to intent? Shouldn't it be part of the process? And should it not carry considerable weight? Isn't this one limitation to a random, subjective public purpose? In that connection, I think that it's also very important not to consider, again, not to consider as a public purpose reservations in treaty. And this is why, what we identify as the duality. Reservations in treaty have an objective, subjective component to them that at the end of the day cannot be circumscribed within a conceptual framework that will work. this is the reason why. The methodology for the negotiation is typically pursuant to very clear rules of understanding that are objective and unassailable. That's what makes the communication, the negotiation possible in the first instance. But the happenstance, the circumstances, and the needs attendant to those objective, clinical, sanitized methodologies, if you will, are purely subjective. So that the reservations, in effect, cannot speak for the needs of an international community, but rather here it is paradigmatic international among or between two states. So we have to keep those out. Going back then to the FIPS, what do the FIPS also do for us? The FIPS also provide an already existing mechanism where states can begin to provide content to public purpose, content to situations where the regulatory exercise of sovereignty will trump the equally binding obligation to protect foreign investment. This can be done in one of two ways. This can be done in isolation. Each country can do it. It can be done in isolation with guidance from the United Nations, or it can be done even in a more coordinated effort. Now, of course, you're going to say, well, this aspect of it is extremely aspirational, and I will not, debate that. We know this is extremely hard, and we know that the path towards trying to get some sort of clarity along these lines is difficult. And that's why if you go to the last couple of sentences in the book, you'll see that there's a reference to Ovid and the Metamorphosis. And there in Ovid, in the Metamorphosis, there's a very beautiful passage where Aeneas is looking for his father. And in order to reach his father, he confronts a Sibyl and says, can you guide me through the field of hell so that I can spend a moment with my father's shade? And the Sibyl looks at him and says, man of honor and dignity, courageous man with piety that has been unassailed, of course I will guide you to your father. And she says this, es nulla via in via virtuti, because for virtue no path is impossible. So this may be very, very difficult, but it's not impossible. And I know that people like you have the virtue to pursue it. Thank you.
I think in the last few minutes, we'd be delighted to answer any questions that you might have, or to allow you to escape for hopefully a very nice weekend.
From your research, how do you think these trade law notions that then were put into NAFTA, et cetera, are going to translate into the public purpose type clause in the new EU treaties? There's a lot of reservation for regulatory space and legislation in the public interest. Do you think it's going to have an impact, or is it going to be a sui generis type of interpretation?
I think it's already having an impact, and I think it's had an impact. It's broadened it considerably in ways that have been taken, again, intuitively and for granted. If you look at a lot of the policy rationales, underpinnings of trade law, public purpose categories or spaces or regulatory spaces, if you will, you'll see that they have absolutely very little or anything. They have nothing to do with the protection of foreign investment and how you can manage the two. So the net effect of that, I think, is broadening that regulatory space in a way that will be pernicious, I think, when viewed, and I qualified, through the lenses of foreign investment protection.
International law doctrine of police power as something different, or having different roots than the sort of trade law recitation of distinct government purposes?
Well, I think, yes, actually the three spaces are a little different. The public purpose that we're talking about as well. What police powers generally, historically, have really almost been identical with the historical formulation of the public purpose. Well, you know, these are states, they're sovereigns, they have a territory, they can pretty much do what they need to do. In the narrow sense, police powers maybe are more order and security, but there are many countries that would construe police powers, I think, as social welfare, as good morals, whatever that may mean, as you know, anything that the state wants to regulate. So I think that's distinct from what we're talking about. As we've said, we think that the doctrine should have some meaning and not be self-judging and deemed intuitive. But it's also different, I think, from in the trade context as well, where the reservations that Pedro's talking about, really, many of them are areas where states are saying, for purposes of a trade treaty, we just want to carve this out. They're not saying that it's a legitimate governmental function per se, but simply that we want to maintain our right to be protectionist or our right to impose different standards. But clearly there's a huge degree of overlap, which is why we see the GATT Article 20 exemptions imported in ways into NAFTA and into the new EU documents as well.
For example, is regime perpetuation, the exercise of police force in furtherance of regime perpetuation, is that a legitimate use of public purpose? What about if it's regime perpetuation in furtherance of an ideology? Let's nationalize all the banks. What if it's regime perpetuation in furtherance of a party in power? These are, even you see that even within police powers, you have different onion layers that raise more questions than they could ever aspire to answer. Yes, sir.
Do you have an example of a favorite example of a case that, in your view, had a bad outcome that hinged on a reading of what should or shouldn't be public purpose that conflicts with your prescriptive view of what it should be?
Well, the reality is that I feel that the use of public purpose in a number of cases conflicts directly with the way with what I view it, the way I view it. Both Methanex and Metalclad, I don't want to pick one side over the other, I think destroy the concept completely. I think they're horribly decided from that perspective. Now, you know, do I think that there was something happening in Metalclad with the dichotomy between, you know, the local government and the federal government? Do I think that the University of California report had something to do with Methanex and the methyl butyl tertiary ether, or whatever that thing is? Yeah, of course. And is there merit? And perhaps they reached the right decision. Maybe. Reaching the right decision is something very different than getting there for the right reasons. And those two cases, and you know, if you look at other cases, you know, TechMed, you know, not a NAFTA case, but a case that is typically held together with NAFTA because it has Mexico and it's studied that way, even though it's a Spanish investor, Fireman's Fund. If you look at all these cases, how public purpose plays a role in these cases, I think it leaves a lot to be desired. You know, how do you build on these cases? How do I square the circle? One thing that I thought you were going to talk about was, you know, how we have
suggestions.
We have some suggestions on how to start doing this that are very concrete, but we're not going to bother you with that.
I just add to what Pedro said. We haven't identified a case really where an investor or other party has said, this is not for a public purpose and therefore it has this consequence, and there's been a really clear articulation and application of the doctrine. The cases that we're talking about really are fighting or making assumptions about the role of the doctrine. And we're still in the same place that the restatement has identified, that because the consequences of public purpose are still being fought over at some level, sometimes unconsciously, we don't see people saying that public purpose has this consequence and therefore we're fighting over the meaning of public purpose. Well, I'm hoping that we'll get there and have some great horror stories to tell.
What do you think about in one of the more recent decisions in the VESP arbitration award, which involved Venezuela and came out earlier this year? The tribunal there, as you'll appreciate, is an April award, dealt with whether or not there was a reasonable nexus between Venezuela's policy to increase food supply for its citizens and the specific expropriation of agroflora, which was the entity involved in that case. And in that case, the tribunal looked at whether or not expropriating this particular beef cattle enterprise actually increased the supply of food to its citizens. And the tribunal, on balance, found that it probably didn't, but it reserved judgment. It didn't make a holding, because when it looked at the next criteria for expropriation, whether or not procedural requirements were followed, it found that they were not. Have you read that word, and what do you think of that tribunal's attempt to address, at least with Venezuela, posited as the public purpose for that expropriation?
I'm very familiar with the award. I will tell you that's something that I will not address, because I'm in the middle of something that's pending, and then I've got a second thing that's pending that are, in the neighborhood of what you're talking about.
I think we can say this. We can say that concepts of proportionality and of futility are concepts that ought to be considered in the doctrine of public purpose. I mean, that's among our recommendations. Public purpose may not be a binary choice. It may be something where whether a regulation is taken for a public purpose needs to be considered with respect to the asserted end, whether the measure meets the end and whether the measure is proportional to the end. And that may relate to the case that you're talking about.
Have a great weekend.
Yes, no. Please join me in thanking Mr. Pedro Martinez-Fraga and Mr. Ryan Reetz with this wonderful presentation for the book. We want to thank Lamise and Diana and, of course, Marco that put all of this together. And on behalf of Young ICSID, thank you again for coming to the event.
Thank you.